boom. Hello, everybody. Oh, one of those days today. Let me wear my hat. How are you doing, everybody? Hope you're all well out there. Um, boom, boom. Oh, right. Let's get to the chat. What we got? Kelly Eggleston. Hello, my darling. You're back. We missed you being one of the first people here, Kelly. I know I'm putting pressure on you now to say you're going to be one of the first people here, but nice to see you, Kelly. Hope you're well, my darling. Tim, Space Coast. Hello, sir. How are you? Hope you're well. But it's hump day. It is hump day, isn't it? Fuck. It is. Today, Wednesday. I know. For some reason, I thought it was Thursday. For some reason. Christine, hello, my darling. Thank you. And congratulations on reaching 505 subscribers, which is good. Well done, my darling. Good morning to you, Ashley. Hello to you. Hope you're doing well, my darling. Hope you're very well. Carol, hello, my darling. I just seen your notification. Rewatch crew. Hope you're enjoying it. Hope you're well. Hope my nieces are well. Hope the family are well. And it's nice to see you. We miss you when you're not around. So lovely to see you, Carol, as always, the Disney Queen herself. We've missed you, my darling. I hope you're well. Dana, I don't hope you're well. I'm joking. Hope you're well as well, mate. I am, as you know, me, Dana. I'm like a duck walking at the minute. I just can't walk. Walk like a duck, talk like a duck, must be a duck. So I'm like a Canton duck at the minute, walking around going like this. So yeah, Dana, I know you're doing well with the challenge as well, but I'll tell you who's smashing it is Dennis Sweeney. Dennis Sweeney's like, you two young pups, I'll show you how it's done. Dennis is smashing me and Dana to bits. So well done, Dan. You put us to shame, Dennis. You put us to shame. Oops. Dana, hey Gary. Unfortunately, I won't be able to stop. Got some family stuff going on, and what happened in the middle of the night will just I'd like to shoot. No worries at all, Gary. Family comes first, my friend. Hope everything's good. Look after yourself, look after the family, Gary, and yeah, keep in touch, Gary. Thank you for popping in. But yeah, family definitely comes first. We always say that. So lots of hugs and thinking of you, Gary. Disney Queen, miss you guys. Too, all good, just super busy, happy days. It's nice to be busy, but it's also nice to see you, Disney Queen, as well. And thank you for being a member for 16 months? Woo! Time has flown by, hasn't it? I didn't think it was 16 months, Carol. I thought it was going to be like a year or something. 16 months, wow. Well, thank you. You've been a staunch supporter since day one. Since you've been on this channel, Carol. So thank you so much, my darling. And it's good to hear you're busy. It's always good to keep busy. Gary, much love to you. Crystal, good morning to you. Snow day today, Crystal. Oh, nice. No worries, Gary. There you go. I guess senior discount 1,000 steps over. You do. You still smash me, Dana. I've just done 2,000 today. I'm struggling today. There you go. You are stuck with me even if I can't be on. And that's all good. You're never stuck. We love you. We love having you here. You know, I love having you here, Carol. We're always making breakfast. Nice. Breakfast in bed, hopefully. Nice, Crystal. That's the way. Got him trained already. Happy days. Well, today's going to be a short day today. I've got some, what do you call it, internet issues. They're shutting off my internet around 4 o'clock my time, which is about 11 o'clock your time in Eastern. So not good. So it's going to be like a 2-hour stream today, which is fine because back tomorrow, back on it. But yeah, and that gives me some time to get some steps in as well, hopefully this afternoon. And also the trial, this trial we're covering, people, this is wild. There's only like half an hour coverage from yesterday, but I got another video then I can play to give you the inside of what happened offline as well yesterday. But it is mental. Mental what happened yesterday. French toast, I like French toast, Crystal. I do like it. Oh, look at this. Disney Queen. Always generous, way too generous towards me. Way too generous. I don't deserve you, Carol, honestly. Um, but congratulations to LB, Ken Hathaway, April, Cowgirl 33, Chrissy Gowan, um, Sabiwa, Kendall McDermott Scudera, KD Giovanni Pikachu, Jen Dalgos, Giraffe 3 Baby Lover, Lisa Hawkins, Just South of History, The Goodmans, Taylor, COT2013SS, Ashley, Sia, Texas Girl XOXO, Kerry, and Eliane. Well, thank you. Congratulations to all of them. And thank you so much again, Carol. Way too generous. Way, way, way too generous. But thank you, my darling, for your continued support of me and this channel. Awesome. Do you know what a great start to the day. What a great start day. I thought today's going to be a shit day because short stream, can't walk, struggling to get off my seat. But great start. Great start. Love French toast. Thank you, Carol. I sent pictures to the happy days. Carol, you're amazing. Yes, she is, and she actually. I was hoping Megan will get a membership. Oh, yes, Megan. You know I love you some Dylan Archer. Thank you, Carol. I really do appreciate you, my darling. And someone else I appreciate, but she gets on my nerves, obviously, is this one.
Erin Hatchie drives a bus, yellow bus, yellow bus. Erin Hatchie drives a bus all day long.
There you go. Hey, Erin Hack. Love me some Carol Delanel Chatty. Thank you, Crystal. We love you as well. And Sassy Barton, hello, my darling. How are you? Nice to see you. To see you nice. Lovely to see you, Sassy. Well, love you, Crystal. There you go. And Blast from the Past. Look who's here. Look who's here, everyone. One of our favourites. I love this woman. Lauren M. Lauren, how are you, my darling? I've been meaning to reach out to you. How are the new dogs doing? How are the pups doing? I don't know the names of the pups, but how are they doing? I hope they're settling well. You know, we all know that, many of you know that Lauren lost two of her beloveds, and she's got new dogs, and I've seen some pictures, cutie beauties. I just don't know the names of them, Lauren. I hope you're well as well, my darling. It's so lovely to see you. It really is. Erin, Carol, she's driving a bus. She's driving the bus, everyone, the yellow bus. Good morning, Lauren. Good morning, Sassy. Doing great. Happy days. Have one new pup. I was like, oh, I thought you had two. Sorry. For some reason, I thought you had two. Holly Louise. Oh, that's cutie. I cannot wait to meet you and Holly Louise in May. I can't wait, Lauren. It'd be a pleasure to meet you. A little pleasure to meet everyone. But you've always been good to me, Lauren. So lovely to meet you, my darling. And Holly Louise. Be safe, Erin. Hope to be here for a bit. I'm only going to be live for 2 hours, by the way, people, obviously, because of my Wi-Fi. Dana, Speedo Man. Dana, the Speedo Man. I can't even find the songs anymore. Dana and Dennis walking down the street. Dana and Dennis, the kind of like to me. These two Speedo men, they definitely growers, not showers. I should train my voice. I can't do it. My voice is gone. Texas Girl, thank you for the membership. DQ Karen, you are more than welcome, Texas Girl. Welcome to you. Nice to see you. And thank you for popping in. Thank you for popping in as well. And saying thank you. Not many people do that, but thank you, my darling. You're welcome. There you go. Hot Mama's in the house, everybody. Behave. Hot Mama's here. Let me pin the message. There you go, Hot Mama. Josie, a little chatty. I know it's wild. I'm busting. What do you think of me then? I always bust. Yes, this is people. This trial is wild. This trial is, you will bust. Yes, wild. So, whew. So Erin is only right. So Erin, calm your tits, Erin. Right, calm your tits for a second. Let me explain. This trial, people, Even if you've not watched it, I've never seen anything like this before, ever in my life, people. So I'll get onto that now. Lisa Emma says hello, send the best. Oh, Lisa Emma, hello Lisa Emma, and hello to Lisa Ella as well when she wakes up. Nice to see you girls. What are you doing today? So the Colin Griffin trial is only 30 minutes, right? 30 minutes. But what a 30 minutes is going to be. This is wild, everyone. It doesn't matter if you've never watched this trial before. It doesn't matter. This is wow. And I've got another video then to explain what's going on in the background as well. It's like a 20-minute video. People, I've never seen this before in my life. Never. So what we're about to watch. But then, Erin, it's gone. So Colin is testifying today live, but we'll catch it tomorrow when we do Zoom tomorrow. I believe he's testifying today, Erin. I believe so. So, swing it, girl. Hey, Tudley Pip. Hello, stranger. How are you, my darling? I'll see you for ages. Let's go, girls. I'll see you for ages. Hope you're well. Tuds. Pixie, hello, my darling. Good day, mate. How are you? Sheila. Pixie, how are you, my darling? Nice to see you. Those of you that cheaters will know what's coming today, which is probably 80% of the chat. Those of you who are not cheaters, you're in for a ride. Ride 'em, cowboy. Let's go, Crystal. Ride 'em, boy. Yeehaw! So we're in for a bit of a ride today, people, up and down, in a good way. So should we get into it? So I got the Law and Crime, half an hour. I got another content creator, which I gotta have to pause it because I do not want another creator striking me. So if I get another strike, I'm possibly going to lose this channel. So I got to be careful with who I got to be careful. So I'll be pausing like a motherfucker on it. But I don't think she will strike me. She doesn't seem the type. This Sheila should be sleeping. Well, join us for a little bit. It's only next hour. Let's go. Look at this. I told you. Josie's on my ass. She's like, get the fuck going, otherwise I'm going to hit you. Right, let's get going. Let's get going. Right, let me get my headphones. I built this up. The trouble is, right, this is what I do. I build it up and then I disappoint. All the ladies say that. You build it up too much and then you disappoint. I'm like, I'm sorry, it's not my fault to bust early. Right, here we go. You're all going to bust early this one. Blue balls, it is. Right, let me play it then. Less talky, more content, buddy. I know I have. This is also Aaron Hack built it up. So to me, right. I've not watched it yet. Hey, Christine. Congratulations again, Christine. Oh, shit. Oh, shit. Hang on. Here we go. I think it's open statements first, isn't it? State arrested. We're now on to the defense.
Welcome back, ladies and gentlemen. I hope that y'all had a nice.
Good morning, ladies and gentlemen. Now it's our turn. Mr. Moore and I have been waiting for a long while to be at this point. I was going to say it's been a week, but it's been longer than a week. It's been years. My client, Zach Hughes, has been waiting for a lot longer than that. He's been waiting over 3 years, some 3 years and 3 months. As Mr. Mormon told you at the outset of this case, we are honored and privileged to be representing Zach. You're going to hear about Zach in the next day or two. You're going to hear that he's a very gifted and accomplished young man. He is 32 years old now. He was 29 when this happened. He's from a wonderful family. You've probably seen them seated back here in the courtroom throughout this trial so far. You're going to hear a little bit about his life. He was born in California. When he was still a boy, his parents took Zach and his brother, moved him to South Western Virginia, where they moved into a small farm, and then they took on 5 orphan children who lived there with them. And you can hear that Zach was homeschooled. He learned the value of hard work and discipline as he grew up around the family farm. He helped his young siblings. His family moved to Greenville when Zach was a teenager. In Greenville, he finished high school, being homeschooled still. And you'll hear that his hard work and his discipline paid off, and he was accepted into a very fine college with scholarships. He went on where he studied music, and he won piano competitions. His emphasis was on piano performance. As an adult, Zach has had an accomplished career performing classical music and even recording classical music. So this is the time now for our case and for Zach to testify. But understand, ladies and gentlemen, that we have no obligation under the law or the Constitution to be doing this. This case actually could be over when the state rested. The state has the burden of proof of proving this case in every element of every charge beyond a reasonable doubt. We would not have to put up anybody. Zach wouldn't have to testify. Wouldn't have to put up any witnesses. In fact, if Zach were not here, his honor would instruct you that you couldn't use that against him. But we are going to do so. And Zach is going to testify because Zach has been waiting for this opportunity to tell a group of people like you what really happened, which is that he took the life of Christina Parcell. And crucially, he's been waiting and wanting to tell you why. Now, the why to a case like this is very important because it goes to the heart of the matter, and that is malice. Okay, malice is what makes a homicide a murder. And we heard from that from the prosecution's opening, as you recall. The prosecution said that Zach was mad. They said he had an angry heart, that he wanted to inject himself into this custody dispute of somebody he knew. But that's not why it happened. And that is not what you were going to hear about why this happened. Now, as we turn to our case now, it's important to realize that we could have handled this case extremely differently. Okay, we could have attacked the sufficiency of the state's case. We could have brought in an expert to talk about the DNA. Okay, we didn't do that. We could have challenged the identification evidence. And I want you to consider the professional from law enforcement, from the state law enforcement division, who testified about the enhancement that they did on the videos and the photographs, and how they were able to use this fancy technology to enhance and to account for the differences between sunlight and shadow and the distance. And after all of that, and after all of the technical work that was done, the conclusion was that the guy on the bicycle was 6'5", a big guy like him. Well, as you probably noticed, and as you will see, Zach is shorter than I am. On a good day, I'm 10 foot. I'm 6 foot, 5 foot 10 inches. Okay, he's shorter than I am. Consider the other professional. There's one who spent a great deal of time looking at the enhancement of the person on the bicycle. And after all that time, what was that conclusion? That this person had a beard. It has to be a man. And they enlarged it, and they used, again, all of that technical information to take a look at it. This guy had a beard. This is before they had any suspects. Well, what do we know about Zach and what we learned about Zach? He was clean shaven. We know that from a couple of days prior, and we know that from a couple of days after. We could have attacked that. We could have attacked the identification from the neighbor. As you remember, a neighbor, after 3 years, came into court. And all of a sudden, after 3 years, was able to identify the man whose picture had been on television for the past 3 years. Had never told anybody even that she could identify somebody. And this was somewhere between 8 and 8:15 in the morning. And what you're going to find, ladies and gentlemen, is that couldn't have happened because the person on that bicycle was not even in that neighborhood for at least an hour to an hour and 15 minutes later. but we didn't attack that. We could have done that, and we could have made mountains of objections throughout this trial. And as you heard, we made very few, and we did not do it. And why is that? Because Zach wants to take the stand and tell you what happened. Now, the prosecution has told you that they will prove this malice in this case by showing you that Zach was mad, that he was angry. And malice is a key part of this case because malice is the very essence of the definition of murder. Okay? So what is murder? Murder is the killing of somebody with malice aforethought. And what is malice? The prosecution told you it's anger, that is madness, and that is a component of it. The definition, though, it is the killing of a person without just cause or excuse, the intentional doing of a wrongful act without just cause or excuse. And I want you to think about those words, that definition, as you listen to the testimony that you're about to hear in this case. The why to the homicide is very important because it gives insight into the person's heart. In this case, you were going to hear that the why was not jealousy or greed or a crime of passion or some other emotion. You're going to hear that Zach did not act like an angry heart like the prosecutor conjectured. You're going to hear that this was not done for money or any other personal gain or benefit, not to help out any kind of friend. You're going to hear that this was done for a just cause. And that's not malice, and that's not murder. Thank you.
Councilman Burke.
So yeah, so they're admitting that he did it, but then he goes in deeper into it than that. There's a lot of sidebars in this one, apparently. Let me just. Hang on, let me find the next.
Ladies and gentlemen, I'm going to send you back to the jury room for a moment, and then I will be back with you. I really want to also thank you just for your patience. We've had a lot of legal issues that I've had to take up with the attorneys, okay? So I will be back with you shortly.
They were out for ages. So what they were discussing in between, I'll play that afterwards. I got a video for that afterwards. It's probably easier to do it that way. Then you get to hear the testimony here now. This is only like what, 10, about 16 minutes. So
Welcome back. Again, I ask, has anyone heard, done any research or anything concerning this?
Thank you. Please state your name for the record.
Daniel Bevel.
Investigator Bevel, you were called in the state's case in Chief. Do you remember that?
Yes, sir.
And my understanding is it correct that you began working for the sheriff's office, Greenville County Sheriff's Office, roughly in 2012? Is that correct?
That's correct.
And you've got a bachelor's degree from Troy University. Is that correct?
Yes, sir.
You testified about this previously, but briefly tell this jury what units you have served in the sheriff's office.
I started in patrol from 2012 to 2017. That's your standard uniform patrol deputies answering 911 calls, any kind of call for service. After that, I went to specialized investigations from 2017 on to, in there, I went to the Crimes Against Children unit from 2017 to 2019. That's any kind of child abuse, child neglect, child sex crimes. Then after that, 2019 to 2023, I went to the Internet Crimes Against Children unit. That's any kind of child exploitation.
Investigator Bevel, you talked about your time in the Crimes Against Children unit. When you're in a specific unit within the sheriff's office, do you receive specialized training associated with that type of unit?
Yes, sir.
Right. And so when you were on the road in uniform patrol, did you receive specialized training related to that?
Yes, sir.
And when you were in the unit of the Crimes Against Children, did you receive specialized training in that discipline?
Yes, sir.
And let me show you. For the depending on what investigation you were conducting or what task you were performing with the sheriff's office.
That's correct.
As an investigator, are you familiar with a phrase called the lead investigator?
Yes, sir.
And ultimately, the lead investigator is just that the investigator on a case who is ultimately responsible for the investigation. Is that correct?
Yes, sir.
And in this case, investigator Sparkman would be deemed or likely be the lead investigator. Is that correct?
That's correct.
Were you also the lead investigator in another case in connection with this case? Let me ask it a different way. On October the 19th, 2021, did you become the lead investigator in another case?
Ye-
State your objection.
Objection, this is going to fall under your previous ruling.
Okay. I will sustain the objection.
Okay. Your Honor, due to Your Honor's previous order with the restriction, I'm going to move on, and I'm going to move on. Investigator Bevel, you testified, as you said, in the state's case in chief, and that was just last week, wasn't it?
Yes, sir.
And I would imagine you're still familiar with your testimony in the state's case in chief.
Yes, sir.
And I want to talk to you about that testimony. And specifically, I want to refer to a specific portion of it. Do you remember during your direct examination, you testified about mailers and the contents of mailers that you had been provided in the early summer and through the summer of 2021. Do you remember that testimony?
I believe so. Are you referring to the mailers as what I was given by
Yes.
Postman Parcell?
Yes.
Yes, sir. Yes, sir.
And you testified that those mailers had nude photographs of Christina Parcell in those mailers. Is that correct? Remember that?
Yes, sir.
And I've got a transcript. I want to ask you specifically about this exchange. Do you remember being asked by Mr. Wilkins, when you first got these photos, let me back up. Do you remember testifying about the fact there was a website listing photographs? Do you remember testifying to that?
Yes, sir.
And do you remember Mr. Wilkins asking you about questions about different fonts and different placement? Remember that?
Yes, sir.
Do you remember Mr. Wilkins asking you this question? Now, when you first got these photos, did you attempt to try to find the website on there? Do you remember that question?
Yes, sir.
And you testified, yes, sir. You remember that?
Yes, sir.
And then do you remember Mr. Wilkins asked you, how'd you do that? And you testified, I just typed the address into one of our computers in the office. Do you remember that?
Yes, sir.
And do you remember Mr. Wilkins asking you, and what did you find? And you testified that the website no longer worked. Do you remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, so you put belladondigiorno.com escort site and put it in your computer, and you responded, yes, sir. Do you remember that?
I believe so. Yes, sir.
And he asked you what happened, and you said, it just redirected me to another escort website. Do you remember that?
Yes, sir.
And then then he asked you, were any of those photos on that escort site? And remember, you testified no.
Your Honor, I'm sorry, I got an objection. Can I?
I'm almost done. One more line.
I'm going to let him ask this question.
You remember Mr. Wilkins asked you, were any of those photos on that escort site? And you responded, no, sir. Do you remember that?
Yes, sir.
And then just one more. Do you remember he asked you, were any pictures of Christina Parcell on any of those websites that you found? And you testified, no, sir. Do you remember that?
Yes, sir.
Isn't it true that in the harassment report that I just showed you, Defense Exhibit
Your Honor, I've got another objection I need to make. I need to put it on the record.
Yeah, this is, I mean,
I'm sorry.
Yeah, I bought a pair of shorts that are too small. Well, they're a bit tight at the minute. So all my other shorts are I can't fit into them. I'm too fat. So that pair of shorts now I bought a little bit too tight, but it means incentive to lose weight. Do you know what I mean? So I haven't got many shorts. I believe in Massachusetts in May it's quite hot, isn't it? Correct me if I'm wrong. Is it quite hot? Hot. Boom. No! Keith, what? Keith, what? So I bought shorts for no.
so again, let's pick up where we left off. I had reminded you of your testimony from last week, wherein you were asked the following about typing in this website. And you were asked what happened, and you testified it just redirected me to another escort website. Then you were asked, were any of those photos on that escort website? And you testified, no, sir. And then you were asked, which you previously testified to, were any of the pictures of Christina Parcell on any of those websites that you found? No, sir. You remember that testimony?
Yes, sir.
Isn't it true in your report on the harassment allegations?
Your Honor, I'm leading.
Your Honor, he's an adverse witness, 611C. He testified for the state. He's a member of the Greenville County Sheriff's Office. I have every single right to lead him pursuant to a 611C.
Your Honor, he is their witness. They call him. In
And what-
direct examination witness, so I'm going to say.
All right. Well, I'm going to show you Defense Exhibit 65 again. Look at this bottom paragraph. Would you please read what I have bracketed to the jury?
Yes, sir. I photographed the 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One contained black and white nude images of Parcell with the address checklist. The images have a web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were not in color.
So is it true, based on this report, that you were redirected to other websites that had the same images that were in those envelopes? Isn't that correct?
No, sir.
Isn't that what you said in your report?
That's poorly worded on my part, but I meant the other envelopes. Same images were not in color.
What are you saying you meant?
The images that were in the other envelopes, not another website.
So didn't you say that you found these on the internet? Isn't that what you said in your report?
No, sir.
Tell me again what you said. Yeah, please read it again for the jury. Read it again.
It's okay if I go to the relevant part instead of
Yeah, and I've got a bracket there.
Okay. Photographed 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One envelope, or it just says one contained black and white nude images of Parcell with the address checklist. The images have the web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were in color. Now, like I explained, it's poor wording on my part, but I was referring to the other envelopes contained several of the same images, but they were in color. I wasn't referring to another website.
And in your report, you don't distinguish between envelopes and websites, do you?
Like I said, it was just poor wording, but I was referring to just other envelopes had the same images, just in color.
And isn't it true that it is very possible that those images could have been online and just taken down at the time you tried to look at them? Isn't that true?
In another website? Is that what you're referring?
Yes.
Yes, sir.
One second. Those are all the questions I would ask Investigator Bevel in this context. Yeah, I don't have anything further on the examination.
You want me to please the court briefly? Did you ever find naked photos of Christina Parcell on the internet when you checked?
No, sir.
It's because it didn't exist that you could find.
Not that I could find.
No further questions.
Nothing else, Your Honor. Okay. Okay.
Ladies and gentlemen, today has been a little bit of an unusual day just because there's been a lot of legal issues that I've had to go over with counsel, and I am grateful for your patience. As I've stated on numerous occasions, I thank you all for your service on behalf of the state of South Carolina. I thank you in Greenville County. I'm going to allow y'all to break for the day. I'm going to ask that you come back at 9:30 in the morning, consistent with my admonition to you all. Again.
Okay, that's the end of the day. That's all there was in court for the jury yesterday. That's all they had. Right, so my meaty dirty bastard. Right, I'm gonna play this. Right, bear with me. I wasn't gonna play it, but then I don't think she'll mind me playing it. Pretty Lies and Alibis. She seems quite a nice person to me. So shout out to Pretty Lies and Alibis. We'll do it educational like we always do. for fair use. So she's in court, and she's updating people on Twitter. Yeah, we've been paying off. I'll tell you what, I'm so sore today though. So Pretty Lies and Alibi, she's in court, and every day with a few other people. So Fitz News and all them. So she's going to give a bit of a what we don't see on the stream. So what happened yesterday that we don't get to see. So I'll play it in bits for us now and see what we get. But yeah, shout out, thank you to Pretty Lies and Alibis. But I'm going to have to start it because I don't want another strike. So we will, even though I don't think she's a type, but still, I will stop it and we'll discuss it.
What you know, Alibis, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Tuesday, February 18th. We were back in court today, and it was also the first day of the defense case, although not a lot of testimony, at least on the live stream. We're going to get into what happened. Before we get started, if you're watching on YouTube, don't forget to hit subscribe, like the video, share it with your friends, and you can click that little bell icon. He now might take the stand in Zach's defense. And that would have been the case if the judge would have allowed the defense that Zach was going for to come in. He was looking to put up a defense of others case. What is that? It is the defense to liability for an alleged crime that is in defense of a person other than oneself. In other words, Zach admitted to killing Christina Parcell. The jury heard this today, and the reason that he was going to put forth is because of the concerns that the child was in imminent danger of being abused. So let's look at the argument that happened outside the presence of the jury and not on the live stream about whether or not to allow Zach to get on the stand and use this defense. The defense says that they're entitled to pursue a defense of others case. If the person who was being protected had a right to self-defense, the person who acted had a right of self-defense. There are elements of self-defense. The child must be without fault, and the defense says she was victimized through no fault of her own. Both Christina and Brad abused her over multiple years. The one thing that the state and the judge both agreed on is that the child wasn't in imminent danger because she was at school at the time her mom was killed. So the defense says, are we saying the child had to get home and wait to be victimized? No, she was in imminent danger of being abused. The abuse was so bad, and the family court believed the child was in imminent danger. The duty of retreat does not apply to Zach. He stands in the child's shoes. The judge goes back in chambers for a bit, comes out and says that this defense is not allowed. He says that the defendant traveled to the house, sought Christina out to murder her, and you can't escape criminal liability. Zach unlawfully entered the house and used the defense of others as a shield to his actions. The defense also wanted to argue the malice without just cause. They believe it's admissible for them to argue to show that Zach did not have, as the state said in their opening arguments, an angry heart. He went in there with no malice but to protect the child. None of that coming in. And we got to the defense openings. The defense says Zach's been waiting over.
So that doesn't get in. The whole thing that he's saying about the child, that doesn't get in. That's done before this closing.
For 3 years for this. He's a gifted and accomplished young man. He was 29 when this happened, and he's 32 now. Doing this could all be over because the state has the burden of proof. But ask about lead investigators and say they are ultimately responsible for the investigation. And this had that material. There was child abuse materials on a phone belonging to Bradley Post. Essentially give a summary of the questions they would have asked witnesses that now will not be allowed to testify for the defense due to the judge's ruling about the defense of others. as well as just the child abuse materials in general. So let's get down to what the defense would have asked this witness had that defense been allowed, had Christina's daughter taken the stand and likely introduced what happened to her. He would have asked if he was the lead investigator in the child abuse materials. And on October 19th of 2021, the witness was made aware there was child abuse materials on a phone belonging to Bradley Post. After the investigator was made aware, he went to verify the images, and immediately after seeing them, he obtained an arrest warrant for Bradley Post for exploitation of a minor. He called another officer to respond to the canebrake address to wake the child to put her into emergency protective custody. They talk about the photo that was the basis for that warrant, and after seeing the images, he knew the child had been exposed to abuse and would ask him on October 19th if he dispatched the Facet unit for apprehension of Post, where they went to his residence. And when they got there, they found a guest bedroom with a dollhouse, a pink alarm clock on the bedside table, and found other devices that contained child abuse material. What is Facet? It's a specialized warrant apprehension unit. They track down suspects wanted for recently committed serious violent crimes. The investigator determined there may be one other victim. I would ask the images he reviewed contained the child and her mother, Christina. In the investigation of Post and Parcell, he listed the dates of the abuse from January 1st, 2018 through October 19th of 2021. On October 20th, the investigator spoke to the other minor child's parents and got 5 more warrants on the 20th. He said the images would have deemed this as a violent crime. They go through the devices telling some of the details of what was seen. I will not recap that part. You don't want to know. It's just disturbing stuff, as you could imagine. Based on this review of what he saw Christina doing, they obtained a warrant for criminal sexual conduct in the 3rd degree against Post, and that is a violent crime. He would testify he got another warrant for Post on January 10th of 2022 for buggery, which in South Carolina, that means it has to do with animals. He investigated Christina and Post previously on molestation allegations from John Mello back in 2018. After Mello made a report, he was worried Post was abusing his daughter. On March 16th, 2018, the investigator sent John Mello an email. And in the email, he told John, as of today, this case is officially closed and that he couldn't establish probable cause that any abuse had occurred. I would have asked the periods he testified the abuse was happening. He wrote Mello an email closing a case saying he couldn't find any abuse. The next witness that they would have called, and they did not, this was another summary of what they would have asked, is the owner of a cigar bar here in Greenville that Bradley Post went to a lot. After Bradley Post's arrest, this witness found more electronics containing child abuse materials. Post had a locker at that cigar bar, and the witness would say he saw there were multiple external hard drives and thumb drives in the locker. Knowing why Post had been arrested, this witness contacted law enforcement, who responded and seized the devices. Another witness who is in law enforcement would have testified they executed a search warrant in the locker and seized those devices, took them to the law enforcement center, and the most pertinent devices had multiple files of Christina participating in child abuse material. The next witness they would have called, some of these names may not be 100% accurate. I can't go back and watch on the feed, and I'm in the way back, and sometimes it's hard to hear. I think it is Vanessa Carmala. She owns her own law practice and does family court work mostly. October 2020 through August of 2023, she was the guardian ad litem for the child. And this was a case that Christina initiated after John took their daughter to Italy. She would testify she knows about the litigation between the two, meaning the 3 prior cases between them, and would testify that she wondered why Christina would give up custody to John Mello. She would testify her impressions of Christina. Christina told her she was an open book. Her impressions of Bradley Post were creep factor and that he was gross. She would testify that Bradley Post would not agree to meet with her, and she thought that Bradley Post was bankrolling some of the litigation in family court. John Mello had told her that Christina had been a prostitute and sold drugs. They said that the testimony would have also included the witness's knowledge of a deposition in which Parcell said she took part in a pornographic film. The witness spoke to Alex Fields, a firefighter who is now deceased. Alex told the witness he ran into Christina at Hall's Chop House restaurant and she propositioned him for sex and drugs. He said he declined. As far as the mailers that had the nude photos, the witness got a few. After Christina was murdered, she put the child with Christina's sister. Investigator Bevel made contact after he found the photos on Bradley Post devices, and the witness went to the law enforcement center to meet with him, where they viewed the images, and the witness would have explained the horror of viewing those images of Christina and her daughter. She would say that she knew investigator Bevel put the child in emergency custody, waking her up at 10 p.m. and removed her from the house. She would tell whose custody the child was placed in. Christina has never had custody. In the end, she went back with John Mello. If she had found those images before Christina's murder, she would have had the child removed immediately. The next witness is an investigator. One thing that I didn't explain earlier, and I don't want to start over, is that why are they putting this stuff out there now if the witnesses can't testify and the jury can't hear it? They are putting this on the record. The next witness was an investigator, Arnett, and they proffer what he would have testified to. He examined devices, seized and received Post's cell phone first, where he did an extraction and analyzed the data. He would have talked about his findings, and also he had been given other devices, a hard drive from a laptop and multiple thumb drives. He found thousands of files of child abuse materials. On one phone, there were 2,267 photos. Most were with the child alone or with her mother. On a hard drive, there were many photos of Christina and her daughter. One of the hard drives had 4,000 images and 48 videos. On another thumb drive, they found over 2,000 images and 137 videos of child abuse material. Another device, 1,500 images, 81 videos. On another thumb drive, 3,700 images and 47 videos. On another device, 1,826 images. Another thumb drive, 2,400 images and 136 videos. Another device, 184 images. And another device showed 36 images and 4 videos. Y'all, this was so hard to hear. The defense said they would have shown the investigator the sanitized photo and asked him to identify the child and Christina. They would have showed the photo from the phone of Christina and the child, and also an older male with shorter gray hair. They go on to describe what was in the image. I'm not going to put it out there out of respect for this young lady, as well as anybody who may be triggered by this kind of stuff. Eventually, the witness stopped searching the devices because they had so many photos and videos. There could have been hundreds or thousands more, but they had more than enough to prove their case. One drive, there was an error with that drive, so they don't know how many photos or videos might have been on that. They would have asked the witness about making copies of all the electronics for the defendant's investigator to go over. Another witness is an investigator for the defense team. He examined the devices at the sheriff's office due to the nature of the type of material. He would have testified how the child was depicted. In one, there was a third person shown, an older male. Organization of the files were very well organized. There was a top level folder, and underneath that were subfolders with names that would clearly tell you what kind of child abuse materials was contained in those. He went through specific devices like the iPhone and pulled up 20 different photographs. He would describe them to the jury in lieu of the videos and photos being put into evidence. At this point, the judge would not allow the defense attorney to describe the images and says that he is protected on the record. But the defense says it's crucial for these descriptions to go on the record due to the extent of the harm being inflicted on the child. The state says there's no evidence that Zach knew about the photos at the time of the murder. The next witness was Dr. David Corwin. He's a child psychiatrist from Utah. He specializes in child abuse of that nature. To sum up his testimony very quickly, the abuse is toxic, obviously, to the child on many levels, and it can be even worse with the frequency of the abuse. He goes on to say in the last 20 years, they have learned that this type of repeated trauma to children can actually change DNA. It can cause children to age faster, and all of the physical and psychological effects of child abuse of that nature. One of the last things that the state asked the witness on cross, how much are they paying you an hour? The witness said he couldn't afford his services himself, but they're paying $700 an hour for his services. And when asked, how many hours have you put in? The witness couldn't estimate. After all of this proffering was done, Zachary Hughes stands up. The judge advises him of his Fifth Amendment right, asks if he has discussed with his attorneys and friends and family whether or not he wants to take the stand. I wasn't sure, since that defense wasn't going to be allowed in, as well as the child abuse materials, whether or not he would take the stand, but he stood up and said he will take the stand. I believe that could be tomorrow. So we'll see what happens. That was it today. I know it was sort of a frustrating day for everybody watching the feed, but with the judge's ruling that we are on a 30-minute delay and arguments heard outside the presence of the jury can't be live streamed, there was very little streamed to you guys today, but tomorrow should be very, very interesting. I'm curious to see what Zach has to say on the stand. I will be live streaming in the morning beginning at 10 a.m., hopefully, unless there's any arguments before we get started. And then, as always, tomorrow night, I'll recap in an hour or less the best of the testimony so you guys that can't watch can stay current. All right, that's it for tonight. Hope you guys have a good rest of your evening. We will see you soon.
How nuts is this? How nuts is this? What? This is fucked up, man. It's fucked up. It's fucked up because, like, oh man. Do you know what I mean? Oh, I don't know what to say. I'm gobsmacked that this is not coming in. Do you know, he's got to stand there in the jury and the witness possibly and to tell the truth, the whole truth, nothing but the truth. You should go, well, I mean, I can't tell you the whole truth because you won't allow me to tell the whole truth. It's a bit frustrating. Now, you know, it's a moral dilemma for a lot of people. Like, no one should ever kill anybody else and stuff like that. I get that, right? I do get that. But sometimes, you know, look what this woman did to young children and to animals, and you know, jeepers. So he will be found guilty. I mean, if he's not allowed to bring anything, he's going to be found guilty. Whether he testifies or not, he's going to be found guilty. Unless there's one juror that's like, unless there's one juror going, I don't know, it doesn't sit well with me, there's something going on, try to piece it together. You know, you basically need, what you need is a juror to be like Aaron Hack. Like just sat there going, something doesn't smell right, and just won't give in. Do you know what I mean? That's his only hope. Do you know what I mean? So yeah, Erin can never be a juror. She's a bad example. Yeah, you should always bring everything in. You know, I get, you know, not being prejudicial to the victim and stuff like that, but this is just too big. I mean, this is the core part of his defense, being like, I killed her because she played with fucking kids. Do you mean? I never justify murder, but if you do, then this is probably one of those occasions. You know, I just don't understand why. So there is an opportunity, though, that when he's on the stand, that he might say something. He might say something about it, and then it becomes a mistrial. But if it becomes a mistrial, it goes back to the same judge, and the judge is not going to change his ruling. That's the only thing. Yeah, unless he, you're right, Mighty Meat, unless, yeah. But you expect jurors to be presented the truth. I know the judges are there as the gatekeeper, not to let every shit in. I get that. But this is just too important. This bit is just too important. You need to know this. This is why he did it. Like, imagine if he now gets crossed and they start, like, if it was me now on that stand and I get, I do my direct and then they come on the cross and start badgering me, I don't think I could contain myself. If they start going, you killed her, you're mad. No, she's a kiddie fiddler. I killed her because she plays with kids. Mistrial. I don't give a fuck. Mistrial, whatever. I don't give a fuck. I want to get my truth out there. I heard some saying they think some jurors might take a look at Google. I think if half of you were on the jury, then Google would be in flattips, I think. Judge would ask, has anybody looked at? No, nothing, Judge. Hide their faces. No, nothing, Judge. No, look. He admitted he did it. Yes, he's admitted he did it. The defense have informed the jury that he did it, but informed them as well that he will be taking a stand to inform them why. Now, the judge is not allowing him to tell them why. I'm with you, mate. He's got nothing to lose, essentially. He's going to prison. Unless, they have Googled and they know stuff and things like that. But even if you Google it, does it come up? Like, my Google is Aaron Hack. So is it public, all this? Because it's behind closed doors. Is it Fitz News maybe? Oh, Fitz News are covering it, aren't they? So it probably is public then. Because I'll say my gossip column is Aaron Hack. So it's public, there you go. So they could see it then. Melody Parker, hello, my darling. You can't say anything. They can't say anything. Like, the thing is, especially if you like stand by what we've just done, it's like, you motherfuckers, you know, and also the prosecutors know all this. Do you know what I mean? They know about how what she was. She's a kiddie fiddler. And not just that, with animals as well. Hello, Genty. How are you, my darling? Good morning to you, my darling. Nice to see you as always. I don't get it. Are we protecting kiddie fiddlers these days? Are we protecting child molesters? Always a pleasure, never a pain. Hey, Katie Santos. Yes, abusing children, I think, and animals. Do you know what I mean? Bestiality. And she knew full well her husband, or wherever he was, fiance, was doing it as well. You talk about thousands of pictures and videos and stuff, but the police are like, I think CP is worse. Depending on the situation, obviously. Like, unless it's a murder with children involved. until murder is involved. We got about another hour, Hack. About another hour. If it was a full hour, I need to walk as well. I'm like a duck. Come on, Tracy. Hello, my darling. Nice to see you. Has Dana given you his phone yet, Tracy, so you can do some steps for him? I'm always. You let me know if Dana's cheating or if he's putting his phone on the back of the cat or something. The cat's running around. And don't get him a new robe. Don't get him a new robe. Mel says, I thought the state case was very thin. The defendant was a piece of shit and the jury needs to hear the facts. Nothing much next, to be honest, Crystal. There's nothing to cover, really. I think he would get lesser, yes, Katie. I do think, yeah. I think, yeah. I'm not sure what it would work out as, but I think he would, yeah. Did we talk about the hat not long ago? No, I don't think so. Did we? Oh, yeah, we did, but I've not got a Patriots hat yet. I've not got a Patriots hat yet. Once I got a Patriots hat, this is my second. So Hippie Chick bought it for me. So it's a gift. So I've got to wear it. This will be my. I'll get a Patriots hat and then I'll have a Colts hat and a Patriots hat. Right, let's see what else there is then. But yeah, that is not very good. I've not shown you Vinny or all of them. Put your hat on backwards. Fucking hell. Some people like it forward, some people like it backwards. I'd never know. Looks better. Do you think? Lots of people say I look fatter with it backwards. I need to shave as well. And go for the Dana Leonard look, like, you know, with a goatee. Let's have a look then. I didn't plan for it to go past this. Hang on. Turn it back around, looks better, for fuck's sakes. Crystal. They do tweet. They're very good. Turn it back around. You just said turn it back around and just did. Right, no more. Right. Okay, let's have a look at this then. Let's have a look at this then. There's no more things to cover in this trial. Thank you, Mighty Meat. You look beautiful no matter what you wear. But thank you, Mighty Meat, my brother from another mother. Thank you. You see, that's the response I should get. Right. Let's have a look at some of these then. So let's look at backwards there. Brother Council. Let's have a look to see. So obviously the whole thing with Karen yesterday. I think every streamer's gone live and spoken about it. I don't know. Let's have a look to see. Thank you, KD. Thank you, Rhode Island. Calm down. Calm down, Dylan. I'm calm. I'm calm, Crystal. It's all good. I'll just go with the recap at the end that he gives. It's like a 10-minute recap from Brother Council about Karen Reid, the motions hearing yesterday. I mean, I'm sure you've all watched every streamer going. I'm pretty confident you've probably watched everybody. I have not, but you know, I think I was shocked yesterday, obviously, because I said before the break, I was like, oh fuck, there could be trouble ahead. but obviously he redacted a lot of it afterwards then, so we'll see what comes. Here we go then.
Okay, they're two separate issues. Now, if Alan Jackson represented to the court something and it was a lie, he's not in a very good position. Okay, that's not exactly the position that he wants to be in. Why didn't Judge Cannoni allow him to respond at all? Well, the reason is that she was suggesting that all parties that are affected can be properly prepared, which means that he should lawyer up. It's like a hint for him to say, get your own lawyer. You may want to be represented and not say anything that may harm you. Okay, so that's what she was doing there by not requiring him to respond. And if she may have required him to respond, if she would have said, would you like to say anything? He may have said, well, Your Honor, maybe we should break and maybe I should, have a sidebar or something. And then, they would have talked about this then. But that's essentially what she was saying to him, in my understanding. He was saying the defense and the defense counsel, meaning the defense counsel should get represented. Now, remember that Alan Jackson is pro hoc. He's not licensed in Massachusetts. He's licensed in LA and then California. And therefore, he's at the pleasure of the court to be practicing in front of that court. So if this all pans out and he actually made a representation to the court, and there's no good explanation for this, that he was saying that there was no collaboration, they had nothing, and then he suppressed this information from getting to the Commonwealth, and this was with intention, then he's not going to be practicing in Massachusetts any longer. So it's very, it could be.
I think that's what Bev originally wanted. I think deep down, when Brennan went on the record yesterday before the break and said all that, I think she went to the back and she poured a gin and tonic and was like celebrating, going, hey, we got rid of him. We got rid of him. Whoop, 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 whoop. That was before the reduction from it. She wants him gone. She wants him gone, no doubt about that. Hey, Ryan. How are you doing, Ryan? Nice to see you. She was visibly shaking. She wants him gone. And that was probably her best thing until he redacted it. Brennan. The prick. What does Dina call him? I forget. Spunky. Cheating Stacey. Hello, darling. Brendan twisted it. The defense didn't pay the Arca guys for testimony. They paid their accommodation where they come to testify, hotel, those things. So, yes, but she could twist that as well because she should have declared it, is what they're saying. Because, but we don't know when that came out. So I can't really say much because we don't know when all this came out. So we'll see.
Likely that he's off the case. Okay, now this is a little premature because we don't know what's going to happen next week. But if this all pans out, it can be a reasonable possibility that he's going to be off the case. Alan Jackson, which would probably mean Elizabeth is also going to come off the case. So that is what Alan Jackson is facing. He may be facing some sanctions. He may be facing some disciplinary actions. He can be facing some stuff that he doesn't want to be facing. Okay, if this all pans out. Now, what does that mean for?
I don't think he's getting down that route, if I'm being honest with you. I don't think he's getting. Initially, I thought he was going to go down that route, but that's before Brennan corrected, say the defense actually gave me these. Had the defense not given him that, I think he's gone. But I think because defense did give him most, if not everything, I think he's fine. But then the trial would get extended. She really was. Well, so they've got a federal appeal court now on the 5th. So there's that on the 5th happening as well. So, and that's on one of the trial days, hearing days as well. So that has to be heard, and there has to be a verdict from that before the trial happens. So if that doesn't come back in like a week, then it probably will be postponed. So Yeah. Lawyer noted, yeah, EDB did a good one as well. They all think different things, mind. So, it's nice to get a little bit of a coverage from everybody.
For Karen Reed. Okay, let's talk about Karen Reed now, because these are two separate issues.
Yeah. So, in case people don't know, yesterday morning, appeal went in for the what's it called, JLC, whatever you call that fucking thing in Boston. Their verdict about basically they want to overturn the decision, so it has to go to the higher court, and it's going there on the 5th of SJC. Thank you, Robin. SJC. So it's going now. They're appealing that decision. I'm paraphrasing here because I don't have the information in front of me, but it's going to a higher court. I think the defense have until the 700 pages. 700 pages. And I think the defense have until the 26th, 27th to respond, and then the Commonwealth, Federal Court, there you go. Then the hearing is on the 5th. There's court being scheduled with Bev on the 5th, but Bev is kicked to the side, which she'll hate. So, boop, there you go. Federal Court, yeah, they put it in first thing in the morning, I believe. What do you think, honestly think, how will this go? I don't know, Crystal. The reason I don't know how it'll go Tuesday morning is because I've not heard what Alan Jackson has to say. So all we can do at the minute is speculate of what potentially he did and stuff. So I always like to give people the benefit of the doubt. I think Keith simply said he's not going to do anything to jeopardize himself. He may have made a slight mistake here or there. I don't know. We all make mistakes, but I don't think he'll have done anything big enough to get kicked off his case, or anything big enough to be in trouble with his license. So I don't think he's shady like that. Could he maybe have, like, for instance, if it is a fact that he didn't declare the traveling costs and stuff, should he have done that? Yes, he should have. Is that enough to warrant him being kicked off? No, I don't think so. Lawyer thinks it is, but I don't think so. I just think he's like, well, okay, my bad. Yeah, fine. But, Your Honour, if you were to kick me off, I'll be kicking the Commonwealth off then for inverted cameras, or timestamps on videos being misrepresented, or people lying under oath, Your Honour, or or whatever else. Do you know what I mean? So when you weigh it, if that is what it is, it's nothing, Burger. It's nothing compared to what the Commonwealth have put together. So I think that's the worst of it. I think that could be the worst of it. I think if that's the worst of it, then he's sound. He's fine. I think he'd be very, very bad for Bev to do anything except for saying, okay, slap on your wrists, declare everything next time. But even then, we don't even know if that's true. Don't even know if it's true. Maybe I don't know. So I'm only speculating at the minute. I have no idea. No idea. Give him the benefit of the doubt. I think we're looking now at the worst case scenarios. She wants him off. I believe that. I do believe she wants him off. But I don't think that she will get him off. I think it'll be a pro. Love me, Elcha. Love you too. Love you too, my darling. Crystal. I'm with you, Keith. Bev said she was gravely concerned, but never considered the inverted video slipping. Yes, that'd be hypocritical. That, for me, that's worse than not declaring how much a hotel was for an expert. You've tried to deceive the jury. So I think there would be uproar if she got him off. I unless he's done something we're not aware of, then there's nothing. Well, Alan Jackson was asked what she on about. He's like, I don't know. I have no idea what she's on about. So I don't think he's even going to explain anything. I think he's going to be like, what? I've done nothing. Prove it. So we'll just have to wait till Tuesday. You know, obviously everything that these attorneys are saying and stuff, what I'm saying is all speculation based on the worst. We don't know what AJ's going to say, or if he's even going to say anything. He might lawyer up and be like, because you know what should you always do? You should always lawyer up. You know, so. Who's a handsome guy in water? I'm not going to put you back up. It's me. So yeah. So all this is circumstantial. We'll see. As I said, when he came up before the break, I was one of the first to be like, "Fuck, Jackson's in fucking shit right now. Jackson's in shit." But then he got redacted. I was like, actually, he wasn't the feds. He was the defense. Well, you mofo. You just lied then. There should be repercussions for him then for lying, misrepresenting facts. Thank you, Keith. Shady, I agree with you, Deb. I agree with you. If you pay the Arca guys who's responded absolutely not, Christina Rex asked. There you go. Right, let's hear this then. Obviously, again, Brother Counsel, all these attorneys, they're only speaking about the worst case scenarios. Do you know what I mean? So take it all with a pinch of salt. Do you know what I mean?
Whether a lawyer himself or herself lies to a court or misrepresents something to the court, then there can be some disciplinary action taken against that lawyer. So again, it's too early to say if anything's going to happen, but it seems that that's what Judge Cannoni is suggesting, that he should lawyer up. Okay, so that's probably what we might see next week, that he'll have a lawyer talking for him in this proceeding. That may happen. In terms of what's going to happen with Karen Reed. So now here's the issue.
Right, before we get into that, Ashley, I agree with you. Unfortunately, I think it's like, well, it looks likely, unless there's a quick judgment on March the 5th, that the trial will be pushed forward, I imagine. So I think it's going to be a little bit longer for the trial. Also, we got to remember, we got the motion to dismiss, which is obviously going to be, it's never going to pass. But there's a lot of hurdles we got to go through. This is just one of those hurdles. But I think in the long run, I think it's going to work out good, because I think it shows you how shady Spunky Brennan was, or is, as well. And what he did to Bedro as well, and Aidan yesterday, to the boy. He's shit scared of Bedro. Trying to get Bedro off. That's from Morrissey, that is, because I think they want to ban Turtleboy from court again. So there's a lot here. There's a lot of games being played. I like Counsel, but he's not always on point. He's just getting involved in it. But that's why I like him, I think, because it is because he doesn't know everything. So he's not detached, if that makes, he's not 100% biased. I think he believes Karen's innocent, but I like him for that. Do you know what I mean? As in, he's fresh. He doesn't know all the ins and outs, so he's coming in with a broader perspective, I think. I like that, but I get what you mean, though. I do get what you mean. Hi, Ashley. Hey, Rhodes. If they try to remove Jackson, it will push the case past April 1st because of the appeals. Yes. It because she needs more attorneys, and the case will be probably going to the end of the year then. Yeah, that was ridiculous about bedroom TV. Did I not call that? That Hank was going to put the Eden Cow bedroom. Did you call that? I'll give you. You probably said it in one of the 100 chats you're in, so I'm not sure. I'm joking. Good catch. Yeah, I agree with you. Tim, hello. Spanky really want to mention TV? Yes. So
this is all talking about last trial. Okay, last trial's over. This is last trial. So maybe you want to argue, oh, this wasn't fair for last trial. Well, now what? What are you going to do about last trial? Okay, so it's not fair. Now we have a new trial coming up. So make it fair for this trial. So are we going to allow an attorney's actions that he took in a previous trial affect a new trial coming up? That's a question. So the most reasonable answer would be no. just because some attorney maybe misrepresented something on, even if it's, how is Karen Reed supposed to know? She's not a lawyer. And maybe she didn't know about all this stuff. So, this is just Alan Jackson acting on his own. So why should that affect Karen Reed? And now you're not going to allow the ARCA experts to testify. What does it have to do with Karen Reed? Now, there is a remedy that if you don't turn over what you're required to under Rule 14, then that could mean that the court can exclude those experts from testifying. The court can preclude them from testifying. That is a sanction. That's a remedy that the court could decide to impose. But is that the appropriate remedy here? That's the question you have to ask yourself. By Alan Jackson, conduct that he took in last trial in 2024, should that mean that they should not be allowed to call the ARCA experts in 2025 when the trial's not still for another month and 6 weeks? So you can still turn over all information that you want. You can still turn over and have disclosures, and they can be completely prepared for trial against the ARCA experts. So that's one possibility. Judge can say, look, Alan Jackson, we're going to sanction you. You can't practice in this court anymore. Maybe they're going to refer to the California disciplinary bar, or the committee, that they can do that. On the other hand, what are you going to do with Karen Reed? Well, what she could do with Karen Reed, which would be reasonable, is to say, we're sorry that you had this attorney who lied to us or misrepresented something to the court. I mean, let's just say that happens. If that pans out, and I don't want to take anything away. Everybody's innocent until proven guilty. We heard some things today, but we haven't heard. Due process requires for everyone to be able to argue their case. So we don't know what Alan Jackson's story is going to be. Maybe it's a great story. Maybe it's a good excuse. Maybe there's some things taken out of context. We've seen this before. So that's, but let's just assume that he gets thrown off the case. So then what is this going to mean for Karen Reed? Whether the ARCA expert is going to get excluded. So number one, it's very reasonable that they won't get excluded, and they'll just turn everything over now. It's still plenty of time before the trial. What's your argument now? There's no trial by ambush at this trial. Maybe you can argue in 2024 there was trial by ambush or duped, whatever you want to call it. But right now we have a new trial coming up, and we'll give you everything that you want. We'll give all the disclosures, everything that was required under Rule 14. Okay, well, that's one reasonable option, I think. And well, let's take it to the most drastic. The most drastic is, let's say Judge Cannoni says, we're not going to allow ARCA to testify. There's been a Rule 14 violation. We're not allowing them to testify. Now, that's not Karen Reed's fault, right? Whose fault is that? If Judge Cannoni decides that the ARCA experts are not going to testify, that's Alan Jackson's fault. Which means now what you're doing, if Judge Cannoni grants this motion now to strike the ARCA experts, and it was all an attorney's fault, and these ARCA experts, everybody understands how incredibly important they are to Karen Reed's defense, and now they're off, well, then now Karen Reed can have a very strong, legitimate claim of ineffective assistance of counsel. Okay, and then the case can be reversed because of that. So is that what Judge Cannoni wants to do? Now, she may say, look, I'm done with these games. You're not having ARCA. Now, and I don't care about your claim of ineffective assistance. And maybe they'll go through the trial, and maybe she'll get convicted, Karen Reed, if they don't have the ARCA experts. And if they don't have the ARCA experts, then there's going to be an appeal filed. And part of that appeal, if the ARCA experts don't testify, is going to be a claim of ineffective assistance of counsel, which in this case should be clear cut if an attorney was intentionally withholding this information. And if he gets some sort of sanction and get thrown out of the court because of it, you can definitely have a very strong argument of ineffective assistance of counsel, and maybe the case is going to be reversed and have to be tried again for a third time. Is that what Judge Cannoni wants? But that's another option out there. Okay, so those are the three options. Jackson can get thrown off the case, can get sanctioned. ARCA experts can be excluded from the case, and then there'll be a claim of ineffective assistance of counsel, or the ARCA experts will testify, but they'll be able to bring out all this information that Jackson was collaborating with the expert. Now let's go through that scenario. Let's go through the scenario that the ARCA experts will be allowed to testify. Jackson's off the case, so maybe it'll be Anetti or Alessi or Mark Bettero. They'll be doing the opening and closing and cross-examining the witnesses, whatever. And then they bring these ARCA experts, and the ARCA experts testify, and then you'll hear Hank Brennan cross-examining these experts. and he'll be able to bring out all this information, and really try to attack these ARCA experts' opinions. Now, that's what happens in a lot of trials. Okay, I've been in trials where experts are really attacked. Sometimes I attack experts, and I'm able to punch some holes in them. Nevertheless, their ultimate opinion here is extremely, extremely credible. Because even if you're going to argue all these things, you're going to say, oh, you're biased, you're this and that, the other thing. Are you going to get up to the stand and lie through your teeth? Are you going to just right out say that this is against the physics and science when it's really not? Sometimes you can get experts to kind of push your case a little bit stronger. When there's a questionable call, they'll go in your favor. You're not going to get an expert to straight out get on the stand and lie through their teeth. That doesn't happen. You'll get an expert to say, yeah, this person's not as injured as they claim to be. They think they're injured. They're really not injured. Or this fracture is not as serious as it seems to be. That type of testimony. They're not going to say, for example, that there's a fracture there if on the x-ray there's no fracture. They're not going to say that. So it's the same thing over here. For them to get up and say, that based on the science and the physics, nothing adds up, and this is all straight out science. They're not, that's going to be much more difficult for them to say, even if they're hired, even if they're getting paid $23,000. And that's much more of a common argument that we heard. Oh, they're biased, and that's in every trial. So those are the different options I think that I see in front of me. So I think really the person who's most concerned right now should be Alan Jackson, not so much Karen Reed. I think Karen Reed's still going to be in a very good position, whether the ARCA experts testify, whether they get excluded. Now, if they get excluded, it may not be so nice for Karen because you may be convicted. And if she's convicted...
Just a reminder, he's saying that Alan Jackson should be worried based on the worst of it. But I think he clarifies where you're headed in this stream. Obviously, there's two sides to every story. So he is giving us the worst case scenarios of what could happen, not to say this is what's going to happen, because I think he realizes the same as us. Alan Jackson needs to speak now, and he's got his right to speak and put his case forward. So, yeah. So I don't think he's there going, these are the only three options. No, these are three options if he did do something dodgy. Not to say that he did. I know, Keith. You're tripping. I know. But I also think that he's also targeting a market that is interested, and I'm one of them actually, in knowing a bit more extension of it in general, not just for this case. Because one of the questions I asked, because I wasn't sure, because she said on yesterday, this has severe consequences wherever to the defense and the defense attorneys, and I was like, well, can she actually? What can she do to the defense and stuff? And that's why he's basically explaining that. So I've learned some bits of it. Now, do I think that any of this is going to happen to Karen? No, but for me, I think it's good to know for the future if there's any other cases. So,
then she's going to be sitting in prison while there's an appeal, and appeals can take years. And then you never know what an appeal court's going to do. As we saw, the SJC opinion, I wasn't so impressed with. So, who knows? Maybe they're going to find that there wasn't, ineffective assistance of counsel in this case by having the ARCA experts not testify, which would be, again, beyond me. And it seems textbook ineffective assistance if you can't get these ARCA experts to testify, or if you did something nefarious or intentional and withheld and didn't perform your obligations of rules and obligations of the rules of professional conduct, not just the court rules. And an appellate court's not going to find that was not ineffective assistance of counsel. So I think, again, if you're in Karen Reed's shoes, it's not pleasant. You want to stick with your attorney, but ultimately, I think the ARCA experts will still testify. And even if they don't testify, even if Judge Cannone strikes them, there's going to be a very, very strong claim of ineffective assistance of counsel, which again would prompt a new trial. So that could be what we're looking at. So that's my take on what happened today. Some crazy.
The only thing I disagree with him right at the end there was, obviously she could appeal it, but you don't want this to go to appeal. You want it to be exonerated. So You know, that even though, she could appeal it, but for me, it's more about, hey, how can we get her exonerated now? What's fair for her right now than in the future? Because if they don't get to testify, I don't think that's fair one bit. Hang on. Hang on. Right, I got you a French toast. Hang on then. This is Crystal's French toast, people, before I show something else. There you go. This is a French toast that Crystal, her fiance, made. Rob made for her. A bit of sausage, and that looks nice, though. That looks nice. That looks nice. That's quite possible as well, because they submitted that in the morning, didn't they? Look at this. Dana and Dennis. This is Dennis Sweeney, everyone, right? Here's me. I can't get off my seat because I'm so painful. Dana's walking in his dressing gown, and Dennis is out in the snow. Look at him, making all these steps. Look at that. Dennis Sweeney. What a hero. Thank you, Dennis. Right. I need to get fuck this walking. Right. Let me get the other one now then. Hang on. Bear with me 2 seconds, people. I should have had this already. Da-da-da-da-da-da. Ba-da-da-da-da. Oh, hang on, no, what I want to do is do this. Right, so what we'll do is, watch this. Hang on. Right, here we go. This is Emily D. Baker then as well, what she had to say yesterday. I like Emily, so I'm going to speed it up a little bit because I haven't got that much time.
And I'm going to let you argue.
Include employees of ARCA, paper 497, and the opposition.
We're listening to his whole argument.
505. So, Mr. Brennan? Sure.
Urge them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
It's still funny to me.
So I filed a TUI letter, comprehensive TUI letter.
And filed it,
And
I mean,
it was delayed.
he gave it to the court.
And over a long period of time with requests.
Oh, I'm in the wrong bit.
Reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor.
That's true. I remember this.
So you can't, but you haven't. So I'm left with that. You have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive.
The feds.
And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves.
Right.
A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required.
Okay.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
What date was that?
They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now,
yeah, this seems like
It's not
before
the opinion.
trial. This
That's
seems like before trial, last trial. Offered, you guys said he said March 22nd, 2024. Great.
I mean, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Oh, boy.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests. And
so, oh boy. Oh boy. Well, I don't know if we're code red yet, but what Alan said to the court was, hey, we only discussed scheduling. The feds turned over emails that are showing that Alan and the experts are having conversations beyond scheduling. That's not good at all. All right, I'm going to back up because I want to hear the date of the first one. I'm sorry, chat, that we're going to go over this twice, but that's not good. That's not good at all. So
I'm going to skip a little bit because I don't think we need to listen to all of it from her. She'll summarize now.
Oh, the judges are going to be happy. Oh, the judges are going to be happy about that. The judge is taking a recess. Yikes. I'm going to zoom past the recess. I'm curious to see the rest of the response because as we know, law is advocacy. So when one side is done arguing, you should be like, oh shit. And then when the other side argues, sometimes you still go, oh shit. Or sometimes you go, that's wild. So it seems that we might have a defense discovery violation as well. So the judge is taking a recess. I'm sure the judge is pissed because if that happened in between voir dire and testimony, which is what it seems, do we know that for 100%? No, that's what it seems. If that happened between then, it had to be turned over to the Commonwealth. My cat's name is Karen is asking the most important question. What's the relief for that? There isn't any. For the Commonwealth, there isn't any. It gets turned over now. And then if they testify, they get hammered on cross. The Commonwealth has less options. They could sanction the defense, like asterisks, but there's been a lot of discovery shit in this case and nobody's been sanctioned yet. So just sanctioning the defense on this when other things haven't been sanctioned would seem a little imbalanced because there's been a lot of stuff. But yeah, for those of you saying Brennan's making a lot out of this, yeah, but this is a problem. If money changed hands, that has to be turned over. When an expert makes a statement like, oh, visibility with pedestrians, but we don't have to say that though, that needs to be turned over. Those types of statements need to be turned over. So the judge is taking a recess. Guess what? We get the OnlyFan. We don't have the exact dates because of the way the feds turned it over. That's what Brennan says. AJ's going to know more. It looks like that is a long recess. Ooh, a long recess. Are we meditating? What are we doing? That's a long recess. All right. Let's get back to court. That's a long recess. The court needed a minute.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications.
Now you're gravely concerned? Anybody else anxious? Anyone else anxious? Anyone else anxious? You guys are like the court had bubble guts. Maybe. I'm anxious. Now there's grave concern? I'm going to let the judge speak. We might have to go back and look at what the defense represented, because the defense represented before voir dire, they hadn't spoken. I don't know if they re-represented that before these witnesses testified. I bet the judge went back and looked at the transcript. I would have.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Pissed.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
She's pissed. She's pissed.
And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything.
We have chat a lot of the time. You guys ask about people's breath. Adrenaline can change your tonality in your voice. If anyone's ever performed or been nervous or angry, she's pissed. Adrenaline. That's adrenaline. She is so fucking mad. I think I'm going to let her finish. We're going to back up and we're going to
do everything that you just read.
I can, and there's a brief chronology. I think Your Honor should be.
I'll do this twice. I'll talk to you guys about why she's not letting the
24. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts.
I remember that.
And that if either party wanted to engage, the original materials are still protected.
Oh. I wonder if the contract ended with the ARCA experts because of these communications.
This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was
the defense provided the emails? You did say it was the federal government.
Defense, February 13th, 2020.
I'm backing up.
The defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the
So the defense sent you the emails and the outline.
Federal government again, because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right. 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the...
know a lot of you are frustrated. Hold on. I know a lot of you are frustrated. I get it. I don't think the judge is doing anything other than protecting the defense here. The judge is furious about things not turned over during the first trial. The defense has said that it is her opinion that this can have substantial consequence. And the court has said we are coming back in a week, which gives the defense time to prepare. Because this may or may not have impact on the defense. But because the court is so upset, and because what has come in, the court feels is significant, the court is saying, I am done for today, and we are going to come back. So instead of asking the defense to dig themselves out of a hole while the court is mad, I think she has done the right thing and said, I am calling a timeout for today, and I'm going to give the time to the defense to prepare to respond. That is a fair thing to do. If the court just wanted to flame the defense, she would say, explain it to me right now. The defense is being given time, and I think the court is also being given time to back up and review. This is a good timeout. I know it's frustrating. A judge that really just wanted to throw the hammer down on the defense would have said, stand up and explain it to me right now. Stand up and explain it. She is giving the defense time. That is fair to do. But this may be a very large deal. So I know it's frustrating that we are on a cliff at the moment. Like, this is the worst to be continued ever. The Bravo editors could never. It's just like, to be continued. You're like, what? So I know it's frustrating. The court is giving a broad swath to the defense to explain. This may be a bigger issue. This may be a misunderstanding. This may be a gray zone. It's my memory that when the ARCA experts came in for voir dire, the court said, you can't have conversation with these experts. And the defense said, we're bringing them in cold. It seems to me, based on what we've seen, that there was conversation with the ARCA experts after voir dire before they testified. But it is the best of my memory that the court maintained that ruling that they could not prepare those witnesses outside of voir dire, which might be the issue here. But if that was not the ruling, and the court, I'm sure, is going to want to go back through and look at the exact rulings, if the court said nothing at the end of voir dire about whether they could communicate, this might be in the middle. So there are still questions here. It's not great. I have questions, but if the conversations were between voir dire and testimony, there might be an issue. There might be. But we need more info. It looks bad. Agreed. Agreed. But we need more dates. We need more info. Woo! And it's a lot of new information, and the court needs more information. The court's going to want to go back and look at exactly what was said, and is going to need time to do that. So what we're going to do is go back and listen to what the defense thinks is their gotcha moment, and then go forward. So this may be a code red. It may not.
So that gives you a flavour where she's coming from. I'm not going to play it all. I mean, people can watch it as they want. But yeah, have we got the other video now? I mean, I think they're all. I hadn't thought the take that she just had. I hadn't had that thought. Do you know what I mean? So I do like EDB. I don't always agree with her. I think she's over the top a lot of times, but I don't mind her recaps. I just don't. I can't handle her stop-start in trials. In a trial. All right. Does he do it? Bear with me. Now, do I sound drunk? Why do I sound drunk? Is it my mic? Right, just a little bit of Peter Tragos there. I'm not going to go too in depth with him, but a little bit here. Okay.
Will be more. Let's get back to Brennan's argument.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
I don't know if it was ever cleared up. Well, you should know. If you're going to make this argument, you should know. By the way, if anybody's counting 11 plus 7 is 18 and he said 20. Like, is that prejudicial? A, no. But B, remember that, right? Let's remember that for when because we're going to listen to Alan Jackson discuss the background. Actually, I don't know if I kept it all in there, so I'll spoiler alert. I think it is going to be in the next clip we watch, but he doesn't actually say a specific number. Yes, you've been tendered as an expert before is basically the question that he asks Dr. Wolf, and he says yes. So he did not say 20 at trial. So was it corrected? Yes. What he said at voir dire, 20 versus 18, I will just tell you, we can make a big deal about that if you want to. I just don't think it would be genuine. I don't think that's a genuine big deal. If you lie to the court, it's a big deal. There is something I do think could be potentially a really, really big deal that some people are brushing under the rug that I am not going to, and people might not be happy about it. But I'm just going to be honest with you with how I look at things.
And then a bill from ARCA to the defense for $23,925.
Okay. And I didn't realize what a perfect transition that was. But a bill from ARCA to the defense for $23,000. I did not hear a date on that bill, so that would be important. My dad and I discussed it at length, who had to pay for them to come testify. A bill is not the same as a payment. I don't know if they paid, but I have to give all these qualifiers because I'm not just going to spout off. Okay. I'm going to put if this, then this. It all depends. That's how lawyers answer questions. Sorry. So if that $23,000 bill was in fact paid by the defense for ARCA's testimony in trial 1, to me, that is a big deal. Yes, I know that after I have not seen the interview with Alan Jackson. I've seen notes from it and tweets from it. And Alan Jackson said that they did not pay ARCA for their testimony, something to that effect. He said it 1,000,000 times. That's been one of the shticks. That's been one of the big deals about the defense. We are also going to watch exactly how that exchange went in trial number 1. Now, I have heard people say, no big deal. He's talking about expert fees. That was just travel and expenses. Okay? Expenses, travel, etc. If they paid expenses, travel, etc., I still think this is a major problem for Alan Jackson and the defense. Because even if you just pay expenses, travel, etc., that is still something that should be disclosed and should be allowed to be asked, especially when it's $23,000, because I can make that sound like a very big number at trial. They paid $23,000 just for your travel and expenses? Did you travel first class? Were you put up in a suite at the hotel? That's exactly the type of questions that were asked to the Rocky witnesses that weren't experts, but he flew somebody from Paris, I think, on a lay down first class, business class, whatever, and put him up in a suite. If it really is $23,000 for travel and expenses that should have been disclosed, that is fair game to ask a witness that. And to say we have paid you nothing, again, words are incredibly important to me. Stephanie, isn't common sense that they would pay for their travel? Yes, that's why I kept saying how shocking it was. Go listen to the podcast I did with my dad. The whole time we were like, gosh, they didn't pay him anything. My dad's like, they had to pay him. That's what my dad kept saying. They had to pay him. The federal government paid him. Now, is this going to be a bill that was paid by the federal government? Well, then that's egg on Hank Brennan's face. Okay? But from my perspective, if you say you didn't pay him and that was such a big deal, and you actually did pay him $23,000, I just would be surprised. I would be surprised if this happened, honestly. So let's take a second now, and we're going to hop over and listen to the exchange, and we're going to try to remember what Hank Brennan said from those emails about Jackson's interactions with ARCA and payment. Okay? Because that's a lot of what was here. And make no mistake about it, we all know, and myself included, this was such a big deal that the feds hired and paid these experts. The defense didn't even have to do it. And there you go. People are saying paid for travel twice. I don't really care. If it was $23,000, that's fine. That can be very legitimate travel expenses. You still have to disclose it. You still have to disclose it. And I don't think Jackson left a lot of room for gray area when it came to payment. Now, he did absolutely leave room for pay or for gray area in their discussions prior. So these are two things we're going to really listen for in this 5-minute clip here. $26,000 paid by DOJ. Okay, again, I don't know. I don't know the answer. All right, so let's take a listen to this exchange between Jackson and the witness. It's really interesting how the chat just goes off the rails when maybe we disagree on one point. We may agree on one, we disagree on one, and you're the biggest idiot in the world. I can't believe you do this. You must be on the books for one side or the other. It's like, okay, if you think so, but this is literally what I deal with. I have to disclose payments to experts all the time. And guess what? I don't just disclose the expert fees.
You are unmuted.
By the way, just to confirm and tell you, Alan Jackson also doesn't just disclose expert fees when he talks about an expert. When they asked for reimbursement for what was paid for the expert, did they include travel expenses? For what they had to pay the expert that flew over to copy the video that wasn't there? Remember that? You guys remember that? Did he include the travel expenses? Because the answer is yes, he did. And again, that's why I kind of think the answer is going to end up being the defense did not pay this $23,000, but I don't know the answer. If they did, it's a problem. Now, if they paid it with case number 2, because now they had to hire them as experts, whatever, no big deal, because the defense turned it over. So it's literally no big deal. All right, here we go.
Now
Yes, you can move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
And I'm going to pause it because each of these points is important. He didn't say 20 times. He didn't say 18. He didn't say 20. He just said, you've been an expert before. And he said, yes.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not who I
So first off, I said you were not hired by the defense. That does not mean they didn't pay you anything, right? Just because you weren't hired by the defense is not the same thing as you didn't pay for anything. Additionally, he said, at the time you did your report. So that's not quotes. That's a parenthetical maybe. That is going to apply to the questions he's going to ask now. At the time you did your report. Let's remember that.
Oh, no, you did not know who I was?
I did not.
You'd never met Ms. Little?
No.
Mr. Unetti?
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
We didn't, the defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
Up until that question, I was actually starting to sweat a little bit, if you want my honest opinion. I was like, hold on a second, because I swear he said you haven't been paid by anything by the defense, because all that stuff, you were not hired, you do not work for, you didn't do the report for, all of those are okay. If you paid the travel expenses, but you asked those questions in front of the jury, that's okay. But you have not been paid anything by the defense. Now, here's a new gray area, right? The new gray area is, at this time, when he's sitting there at trial, had they paid those travel expenses? And if the answer is no, that they did not pay the travel expenses at this time, then that could still be a true statement. Now, I didn't go pull every clip of everything Alan Jackson ever said, from interviews to the courthouse steps. Amy said not paid yet, could be said. But I feel like I've heard him say it 1,000 times that they didn't pay ARCA anything. But if the point is, at the time he said this, that was true, and now they have paid $23,000 whatever dollars, then they have turned it over. It's part, the Commonwealth could not have asked it in the first trial, okay? So there is no prejudice. If they didn't pay him at this point, the Commonwealth could not get up and say, didn't you pay $23,900 or whatever it was? Didn't they pay this for your travel and expenses? What did they put you up in a, nice hotel? They couldn't ask any of those questions because they had not, in fact, paid that money. Timing matters. Words matters. Yep. Sakshi said, what if it was paid after the trial? That absolutely matters. Sarah said, I think she's trying her best to be impartial, but I'm convinced Judge Cannoni despises Karen and Alan. I think Karen should have a new judge. Well, if only it were that easy. But I think she's trying to. I'll tell you where I think she misstepped at the end of when we get to the end of the hearing. I don't know if we're done with this. There's about another minute I want to listen to. There's another minute I want to listen to of the back and forth between Jackson and Wolf at the first trial.
And you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
He didn't say we've never spoken before today, right? At the time of your report, you didn't know who I was. We had never met, never spoken. Fine. But now the question is, and again, you can call it smart, you can call it slimy. My guess is the two sides of this case are going to have two different S words for what you call this and what people think of lawyers, right? They hate lawyers till they need one. That's how this channel started. The original intro, John O'Rourke will remember that, and probably agree with it. But he said, he changed. I never asked you specific questions about your testing.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew.
Right, I got to be careful because I got to go in 5 minutes. So, But the gist of it was, I want to show that because, they're all coming from different points. And the point that even though that lawyer, like Peter's saying, like shady's fuck, if they paid it and did disclose it, fine. But the timing is important. If they paid them expenses, that's fine, as long as it was done after trial. If it was paid before the testimony, then that's different. I think it would have been done after the trial, if I'm being honest with you. I don't think it would be done now, as in before the trial, because expenses normally come in afterwards. So I think at the time when that was happening, nothing nefarious has happened. So he's right that it should be disclosed, but I don't think there was anything, personally, I don't think anything was available to be disclosed, because it's highly unlikely that they would pay expenses in advance. It normally comes in afterwards, and normally comes in like a month or two afterwards. So I got my internet's going to go down approximately 4 o'clock, so I'm just going to go before it goes down. Basically, I'll be back tomorrow 8:45. We get to see Connor Griffin, what's his name, Zachary Hughes, Zachary Hughes tomorrow. He's testifying tomorrow, so we'll watch that. Edie Baker is going live as well in an hour's time, by the way, midday. She's going over that, I believe, the Karen Reid stuff, the motions. Because I did see that, and when I got her up just now. So if I put Emily Baker in, she's got a stream coming up at 12 o'clock. It is Karen Reid appeals again, Commonwealth motion for sanctions. So that is Emily D. Baker. Another appeal if people want to watch that. Bye, Crystal. So yeah, if you want to watch something but Karen Reid related and you like EDB, as I say, I don't agree with everything she does, and I don't agree sometimes with the way she is, but I do think she's very insightful. I think Brother Counsel was very insightful just now, and I hope you learned some stuff as well. On Peter Trigos as well. I don't know who Nan is, but Young Jerks, well, Mike's always a good guy as well. So so please support Young Jerks. Everybody, thank you very much. I have to dash before my internet goes. I got to get some steps in. Fuck. Right. We will see you tomorrow morning, 9:15. Hopefully I've done all my steps by then. So Spacey Stacey, come on. Hopefully you're doing steps. Everyone, love you. Take care. See you in the morning. And again, thank you for being here, everybody. Bye-bye. End stream.